Let me record you.
This conference will now be recorded.
Thank you very much. Okay, thanks everybody. The time is 10:05 a.m. The November 10th, 2020 meeting of the State Medical Board will come to order with the following members present via video conference. Dr. Rothermel. Dr. Rothermel with us? Dr. Rothermel,
Present.
yes. Oh, thank you. Dr. Safran?
Present.
Mr. Jacqueline?
Here.
Dr. Soin?
Present.
Dr. Johnson?
Present.
Mr. Ganadakis?
Present.
Ms. Montgomery?
Here.
Dr. Feibel?
Here.
And myself, Michael Schottenstein, here. Do I hear a motion to approve the minutes of the October 14th, 2020 board meeting as drafted? Motion, please.
So moved.
Second. Dr. Safran, thank you. Dr. Bechtel, thank you. All in favor, voice vote?
Aye. Aye.
Aye. All opposed? Thank you. The board will now consider the reports and recommendations appearing on today's agenda. Has each member of the board read and considered the hearing record, the findings, fact conclusions, and proposed orders, and any objections filed in the matters of Omar Al-Musa, MD, Kanglu, MD, James Thomas Murphy, MD, and Jada Ransom, LMT? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Soin?
Yes.
Dr. Johnson?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Further, does each member of the board understand that the board's disciplinary guidelines do not limit any sanctions being imposed, and that the range of sanctions available in each matter runs from dismissal to permanent revocation or permanent denial? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Soin?
Yes.
Dr. Johnson?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Does each member of the board understand that in each matter eligible for a fine, the board's fining guidelines allow for imposition of the range of civil penalty from no fine to the statutory maximum amount of $20,000? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Soin?
Yes.
Dr. Johnson?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. In accordance with the provision in Ohio Revised Code 4731.22F2, specifying that no member of the board supervises the investigation of the case shall participate in further adjudication of the case, the secretary and supervising member must abstain from further participation in the adjudication of any disciplinary matters. In the disciplinary matters before the board today, Dr. Rothermel served as secretary and Dr. Safran served as supervising member. During these proceedings, no oral motions may be made by either party. Only, respondents and their attorneys addressing the board will be allotted 5 minutes to do so. The board parliamentarian will advise when the 5 minutes has expired. The assistant attorneys general will be subject to the same limitations. Please turn to the matter of Omar Al-Musa, MD. Objections have been filed and were previously distributed to board members. Ms. Lee was the hearing examiner. A request to address the board has been filed on behalf of Dr. Al-Musa. 5 minutes will be allowed for that address. Go ahead, Dr. Al-Musa, please.
Thank you. I will begin, actually. Brandon Smith with Graff and McGovern on behalf of Dr. Omar Al-Musa. As an initial matter, Dr. Al-Musa thanks the board for the opportunity to appear this morning and thanks the hearing examiner for the detailed report and recommendation. It became clear during the hearing in this case that this is not a straightforward conviction matter. Rather, the convictions arose from Dr. Al-Musa's addiction. Accordingly, Dr. Al-Musa asks that the board consider the disciplinary guidelines governing impairment cases prior to imposing a sanction in his case. The impairment guidelines more closely line up with the facts of his case than do the conviction guidelines. I believe Dr. Al-Musa now has a few words he would like to say.
Omar Al-Musa, distinguished members of the board, thank you for this opportunity to say a few words on my own behalf. The Assistant Attorney General of Ohio will outline for you the criminal complaint to which I pleaded. Unfortunately, what she will tell you is true. My actions have led me to this reckoning today. My former colleague and I wrote narcotic prescriptions for each other, which is how I came to be charged with unlawful distribution and health insurance fraud. I truly regret these actions. One thing I want to share is that I did not trade or sell pills for money or favors. Instead, this was done to feed my addiction. The conviction is only part of my story, and today I welcome the privilege of sharing the rest of it with you. 26 years ago, I was diagnosed with Crohn's disease in December 1994. I've struggled with pain related to Crohn's disease ever since. In July 2014, after 7 years of working overnight and with near constant pain from my Crohn's disease, my judgment was compromised and I broke the law. In 2014, at the height of the opioid epidemic, I was no longer prescribed opioids to manage my pain. Physicians were rightfully shying away from opioids in order to address a worsening public health crisis. Unlawfully, I continued to manage my pain using these medications, as they provided significant relief from both the pain and associated gastrointestinal symptoms. The rationalizations that I used were that I was using the same dosages I had been prescribed previously, 30 milligrams of hydrocodone a day. I thought my actions were somehow, in a very twisted way, reasonable or justifiable. In recovery now, I've learned that these were rationalizations, and these rationalizations were really signs of my addiction. My recovery began shortly before my indictment on February 24th, 2018, when I stopped using hydrocodone altogether. After my indictment, and with the help of friends and family, I attended rehab. After rehab, I began regularly attending AA, NA, and working with a therapist. I have a sponsor in AA and also found personal spiritual guidance from the Monsignor Ronald Legenwald of the Catholic Church in Pittsburgh. I enrolled with the Pennsylvania Physicians Health Program and submitted myself to extensive monitoring, even though it would have no bearing on my sentencing. My family, friends, the church, and the Fellowship of Recovery are supporting my efforts to live a pro-social, sober life. I'm in a good place now, and my treating physicians are aware of my illnesses and are working to help me manage them appropriately while in recovery. I have no secrets anymore, and I worked hard to share the message of my story with others, especially physicians, including at the upcoming Radiological Society of North America's annual meeting. The talk will be broadcast on December 1st, 2020, and could be viewed by as many as 60,000 attendees worldwide. In closing, I humbly ask you for the privilege to practice once again as a physician in order to benefit others. I've worked hard on my recovery, and here I am before you, repentant and hopeful. The 12th step is about giving back, and as part of my recovery, I hope that you permit me the chance to do so. Thank you.
Thank you, sir. Does the Assistant Attorney General wish to respond?
I do. Thank you. Good morning, everyone. I'm not going to walk through the facts in this case. I think you have a pretty good record already developed in front of you. I, as in every bootstrap case, encourage you to place more weight on the court records than on the testimony. It is unrefuted testimony. Notwithstanding that testimony, however, Dr. Al-Musa does not have a current license. So the board really can't do what he wants you to do, which is not revoke him and give him impairment terms, because there's nothing on which to put those terms right now. We don't have a pending application. So right now we have an expired license, which expired in 2015. And I think that the board is a little bit more limited for that reason than you would be if you had an active license. So I support the report and recommendation. I believe the hearing examiner's recommendation is the legally correct one. And I would ask that you take appropriate action on Dr. Almusa's expired license. Thank you.
Thank you so much. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Almusa? Motion?
So moved, Dr. Johnson.
Thank you. Second?
Second, Mike Condodax.
Thank you so much, sir. I will now entertain a discussion concerning the matter of Dr. Almusa. Is there any discussion? Ms. Montgomery.
I just wanted to say thank you, Dr. Schottenstein. Dr. Almusa, you have a very impressive resume, and you are make a very compelling argument in your testimony. It's regrettable what has happened to you and what you've allowed to happen to yourself. But all that is, I fear, for me, I have to say that I'd have to go along with the recommendation, not because you haven't done wonderful things and not because your resume doesn't speak soundly about you, but unfortunately, I think the law prevails here.
If I may, we heard today from defense counsel and also in the objections that, Dr. Almusa's case is an impairment case, right? And that the felony convictions are secondary to the impairment and were a direct consequence thereof. But it's my reading of this case is that it was in the absence of addiction that the doctor in 2014 rationalized a choice to engage in felonious behavior. The doctor was not in the grips of addiction when he originally embarked on this scheme to illegally dispense and distribute Schedule II controlled substances. The drug dependency disorder came later, after he had been using the opioids on a regular basis. In the transcript, the doctor testified that he had, quote, drifted, quote, from managing his Crohn's symptoms to having signs that he had a substance abuse problem, and that by the time he recognized it, the substance use disorder had already progressed. The doctor inexplicably did not seek out a specialist to treat his condition. And by participating in this scheme with a colleague, he arguably worsened his colleague's addiction. But that said, the doctor has been compliant with his substance use treatment program. He's been sober for almost 3 years. And of course, I did read in the transcript that the doctor indicated that he would like to have the opportunity to work in Ohio. And so in that regard, I also would just echo what the Assistant Attorney General said today. To indefinitely suspend a license, there needs to be a license to suspend. The doctor's license expired in 2015. There's no application for an Ohio license at this time, and we can't just waive the application process. So if the doctor was within the 2-year window for renewal of the license after its expiration, then we could have granted it and suspended with the standard conditions for reinstatement in impairment cases. But the license expiration is too old for that. A non-permanent revocation still allows the doctor a pathway to practice in Ohio. If and when he applies for restoration of his license, he will likely get a new citation based on the current action. And at that point, he can present the board with evidence of his sobriety and the steps he's taken to maintain it. I think he could conceivably enter into a consent agreement at that point. If I were contemplating such a consent agreement in the future, in addition to the standard conditions for reinstatement in impairment cases, I would consider an ethics course. I would consider permanently limiting the license regarding the prescribing of Schedule II substances. Because it's going on 3 years since he last practiced medicine, consideration could be given to a physician reentry program, such as CPEP or PACE, as a condition of reinstatement. A practice plan could be considered. But for now, I'm in favor of the proposed order, including the fine. Is there further discussion?
Michael?
Okay.
Sorry,
So
Mr.
if there's no further-
has the discussion. This is Benton. I believe Mr. Giacalone has a comment.
Yeah,
If you'd be so kind, sorry.
thank you, Dr. Schottenstein. Yeah, I agree with you, Ms. Montgomery, on all the points. One comment about, in the minutes, the limitation in terms of Schedule 2, I would say any narcotics because there may be stuff that falls out of the Schedule II realm. So narcotics and Schedule IIs is probably should be off the table in terms of consideration if a future board decides to reinstate his license. That's it.
Thank you so much, Mr. Giacoloni. I have a little bit of video glitching on my computer. If I don't see a raised hand, feel free to speak up. Is there any further discussion? Okay, so hearing none, we have a roll call vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Al-Musa. Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacoloni,
Yes.
Dr. Soen,
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery. Ms. Montgomery. Dr. Feibel?
Yes.
Thank you. Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Thank you all. Please turn to the matter of Kang Lu, MD. No objections were filed. Ms. Szymanski was the hearing examiner. We've had a last-minute request from Dr. Lu to submit a written copy of his verbal remarks. For that to happen, the board has to approve that. Ms. Anderson, do you want to speak to that? Oh, hello, can you hear me?
Yeah. Do you need a motion? Accept the written statement?
Right.
So,
Dr. Lu has asked that his written remarks be provided to the board. I don't know if we have an objection from the AAG. I know the AAG was provided with that request.
I'm covering this case for Emily Pelfrey, and we don't have an objection to that.
I'll move.
So then we would need a vote of the majority of the board. And if the board approves that, the document will be emailed to you immediately.
okay, thank you. I think we have a motion from Mr. Giacolini. Is there a second?
Giacoloni Ganadakis.
Yeah, Mike Ganadakis.
Okay, thank you so much. We'll have a roll call then, please, on the motion. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacoloni,
Yes.
Dr. Soen,
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yeah.
Dr. Bechtel.
Yes.
And myself, Michael Schottenstein, yes. Okay. A request to address the board has been filed on behalf of Dr. Lu. 5 minutes will be allowed for that address. Sir, if you'd like to proceed.
Oh, hi.
Dr. Lu, can you hear us okay?
Yes, I can hear you. Are you ready for me to speak? Okay, well, I'm just going to read you the document which was sent to you just now. And so firstly, thank you and the board for the opportunity to address the board on my own behalf. I think this is a difficult case. It requires a little bit of thinking, I guess. So I'm just going to begin in this period of national uncertainty, obfuscation of the truth, and increasing skepticism for traditional institutions, academia, the news, and even for our medical profession. I think it's imperative that we as physicians remain true to our intellectual foundation as scientists and critical thinkers. We must not allow presumptions to be accepted without scrutiny, and we must demand the truth and the proofs, therefore. Truth is the agreement of thought and reality, and discovery is the process of arriving at the truth according to the persuasion of one's own intellect by studying the questions pertinent to the cause. Discovery, or the right to be informed, is a fundamental due process requirement secured by the national and state constitutions. In Green versus McElroy, the Supreme Court declared, where government action seriously injures an individual, the evidence used to prove the government's case must be disclosed to the individual so that he has an opportunity to show that it is untrue, and that these rights apply not only in criminal cases, but in all types of cases where administrative and regulatory actions are under scrutiny. Therefore, in accordance with Article 1, Section 10 of the Ohio Constitution, I respectfully, quote, demand the nature and cause of the accusation against me to be disclosed by the prosecuting attorney, not for the purpose of relitigating a prior case, but to simply reveal what should already be on the record. Because a defect of subject matter jurisdiction can never be forfeited or waived, and however late this objection has been made, it must be considered and decided. Any proceeding without its limits is prescribed as quorum non judice and its action a nullity. And because the lack of jurisdiction renders an order a complete nullity, and it may be impeached directly or collaterally by all persons anywhere at any time or in any manner, I respectfully demand a plain, substantial, and formal statement of the subject matter jurisdiction asserted by the prosecutor in writing for the record. Specifically, it's alleged that I was, quote unquote, arrested for failure to submit to police officers in 2014 and 15. But the Fourth Amendment requires that the seizure of persons be supported by a warrant, probable cause. Can the prosecutor produce a warrant or a statement of probable cause, or show that an exception to the Constitution was in effect? It is alleged that I was convicted of importing firearms, quote unquote, into Canada in 2018, but the Canadian Customs Act clearly defines firearms as a species of goods or merchandise for trade, sale, or distribution of cross-border commerce. After an exhaustive investigation, the Canadian officials found nothing to suggest that I had any unlawful intention or had engaged in any unauthorized commercial activity, and I was released the next day. Can the prosecutor produce any published law to show that the subject matter jurisdiction of the Customs Act, whether United States or Canadian, applies to personal belongings, such as the arms I kept for the security of person, in accordance with Canadian Charter of Rights and Freedoms or the United States Constitution? It is also alleged that I failed to disclose these so-called crimes to the medical boards, but according to the Supreme Court, a crime as a compound concept generally constituted only from the concurrence of an evil meaning mind with an evil doing hand in the causation of actual harm. Not only has no one accused me of any harm, the courts have remarked that the claim and exercise of a constitutional right cannot be converted into a crime, and that there can be no sanction or penalty imposed because of the exercise of the constitutional right. Can the prosecutor identify facts on the record showing that I harmed anyone, or how my conduct exceeded the constitutional rights belonging to me? Can the prosecutor produce the legislated definition of crime so as to satisfy the due process requirement with sufficient definitiveness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement? It is my right and our duty to construe legislation as it is written, not as it might be read by a layman or it might be understood by someone who has not even read it. When a statute includes an explicit definition, we must follow that definition, even if it varies from that term's ordinary meaning. The administrative magistrate in Massachusetts defines fraudulent intent as proof that you knowingly made a false statement and that the subject of that statement was susceptible of actual knowledge. since I have relied exclusively on the Constitution.
Dr. Liu, this is the board. I'm sorry to interrupt. This is the board parliamentarian. Your 5 minutes has expired, so could you please conclude your thoughts?
Okay, yes, sir. Well,
Thank you.
well, my closure is that words give rise to thoughts that form beliefs. And by closely dissecting our own beliefs, we realize that the real lies are the very thoughts that we believed were our own. So when words lose their meaning, people lose their liberty and they perish for a want of knowledge. That is in the history of empires past, and that will be our fate and our children's fate if the law is allowed to be applied according to unproved presumptions or in excess of constitutional limits. Wherefore, I pray that the Medical Board of Ohio may disposition this matter according to only provable facts. 1, I did no harm. 2, there was no crime. 3, that I did not bear false witness. And 4, there's never been a concern for patient safety or professional competence on my part. And 5, that the presumed Massachusetts final order is defective in subject matter jurisdiction and is, quote unquote, a complete nullity. And thank you very much.
Thank you so much, Dr. Liu. You're very kind to share your thoughts with us. Does the Assistant Attorney General wish to respond?
Thank you, Mr. President. Ms. Pelfrey informed me to relay to the board members that she supports the report and recommendation of the hearing examiner. Thank you.
Thank you so much. Is there a motion to approve and confirm the proposed findings, fact, conclusions, and order in the matter of Dr. Liu? Motion?
So moved, Dr. Johnson.
Thank you, Dr. Johnson. Is there a second?
Second, Dr.
Dr. Bechtel, thank you so much. Thank you kindly. I will now entertain discussion concerning the matter of Dr. Liu. Is there any discussion? I guess I have some discussion, if I may. I would first start off by saying that Dr. Liu may misunderstand the purpose of the proceeding today. This is not a proceeding to relitigate the actions taken by other boards or other legislative or law enforcement entities. This is a B-22 case. There has been allegation that other medical boards have taken action against the doctor's license. That's all we're here to determine. And so in that respect, this is simply a case of mitigation. If we find that that action was in fact taken against the license, then we simply decide how to proceed from there. I also found Dr. Liu's statement interesting, that when words lose their meaning, people lose their liberties. I find it to be an ironic statement because I feel like it is the gentleman himself who uses words in a way that causes them to lose their meaning. You know, the meaning of a word is based on how the word is understood within the language. So the meaning of language equates to its use. Definitions of words emerge from the culture and society in which they are used, and the doctor is not attentive to the social and legal context in which language is rendered intelligible. Language must be shareable. Meaning is a social event. It happens between and among users of a language. The gentleman appears to have his own private language with words that mean something to him, but do not mean anything to other users of the language. And so a private language is actually an absurdity, because if words are used in the language as a means of communication, then they necessarily cannot be private. And similarly, if the meaning of words is private, known only to the doctor, then it can't be part of the language. Language is necessarily communal. So when you make a distinction between firearms and arms, when you indicate that you were in an automobile but not a motor vehicle, when you state that you were not arrested despite being handcuffed and booked at a police station, when you maintain that you saw an administrative officer and not a judge, those are all specious distinctions that inform his own private language. And it's certainly the doctor's right to have his own private language and interpret words and language in a way that's meaningful for him. But that right ends when it results in behavior that violates the law. The doctor has deliberately engaged in behavior to break the law because it does not conform with his own personal interpretation of it. And of course, that's not acceptable, because if we universally apply the doctor's behavior, where everyone starts engaging in behavior through the prism of their own interpretation of the law and through the prism of their own moral code, then we have anarchy. So in the proposed order, the hearing examiner recommended a non-permanent revocation of the license to practice based on the election of the Massachusetts board. The doctor is encouraged to wait until he has a full unrestricted license in Massachusetts before he reapplies. So, under that order, the doctor can turn around and reapply any time going forward, but that does not mean the license will be granted. It could come back to the board as another site or a consent agreement, or the secretary and supervising member could decide the issues have been dealt with and grant the license. So I support the order. Is there further discussion?
Yes, hi, I have some discussion. Yeah, thank you for your thoughtful comments. And to Dr. Liu, also thank you for your very thoughtful and philosophical comments. I appreciated listening to those. I tried to put myself in the shoes of Dr. Liu, and I could see a scenario where if you're in rural Vermont and you're shooting with some friends and you happen to put the guns in the car and it's so close to the border of Canada that I could see how you could end up in this situation. And to some extent, it really doesn't involve patient care and that kind of stuff. And I just wanted those things to be noted here, right? But at the end of the day, I think this order is a good one regarding revocation because there's still a pathway forward for return to practice. It's still possible to do that or to reapply. And the fine is a nominal amount. So on that note, I support the proposed order.
Thank you so much, Dr. Sohn. Is there further discussion?
Yeah, Dr. Schonstein. Dr. Schonstein.
Yes, sir, please.
Yeah.
Yes, sir.
Thank you again for your very in-depth research analysis. However, I think as other people have said, the interpretation is a little off, and you've interpreted things that are contrary to what courts have decided in this issue. And also, the thing that bothers me is the rationalization in spite of what seems to be, if not the interpretation, just common sense on this. And it seems like there's a history here with firearms and law enforcement, which is a bit disconcerting. And your reluctance to at least accept or own that, claiming some type of constitutional statutory right. Those things bother me from the standpoint of what does that mean for your practice when you decide, well, this doesn't apply to me and I can veer off course simply because I've interpreted that. And that's a little bit where I struggle with your situation in terms of how you approach things. And I think even some of the evaluations, medical evaluations have kind of pointed that out too. So again, while I appreciate everything you said, I struggle a bit with your positioning. And again, I would have to support the view of, I think, the people that have stated before. I think you do have an opportunity to come in, but I think right now the revocation process, and I think one of the comments the Attorney General made about, adherence to the Massachusetts Board of Medicine's requirements really need to take place before I think we as a state feel comfortable allowing you to practice in here. And I'm sorry that's the situation, but I think that's where at least I struggle with it.
Okay, sir, I'd like to address the board.
So, sir,
I'm sorry,
your
Dr.
turn is expired.
Dr. Liu,
is there
there's no opportunity for you to address the board again.
Yes. Is there any further discussion from medical board members, please? Dr. Feibel.
Yeah, I agree with Mr. Jackalone. And it is concerning the lack of realization of his situation. And for me, that is concerning going forward. So I would encourage you, sir, to reflect on your stance on things and your position on things if you come back to this board for further licensure. And I support the proposed order.
Thank you, Dr. Feibel. Is there further discussion? Okay. I'm hearing none. So we'll have a roll call vote then, please, to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Liu. Roll call, please. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn.
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery, Ms. Montgomery, Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you. Please turn to the matter of James Thomas Murphy, MD. Objections have been filed and were previously distributed to board members. Ms. Lee was the hearing examiner. A request to address the board has been filed on behalf of Dr. Murphy. 5 minutes will be allowed for that address.
Hello, can you hear me?
Yes, sir. Please
Yes, Dr. Murphy, we can hear you.
Okay. I wanting to address the board to object to the proposed order to grant my license in Ohio. I think it is just over restricted, granting a physician license with probation. There's onerous reporting requirements, taking a medical records course, which I've already done, the PACE course in San Diego for the same thing. And this basically violation 10 years ago was not maintaining medical records for one patient. I think you've overstepped your order restricting my license. So I've had 2 other licenses in 2018, 2019, other states in Indiana and Georgia with no such probation, no restrictions, no reporting, no courses needed, no problem. So I don't know what makes Ohio so special that they think I'm a criminal. And looks like I've violated money laws requiring the Attorney General to step in and give all these restricting orders. Basically, that's it. I don't need 5 minutes.
Thank you so much, sir. Does the Assistant Attorney General wish to respond?
I do. Thank you. Good morning again. So Dr. Murphy has filed an application to practice in the state of Ohio. This is a bootstrap action off of a New York State Board of Professional Medical Conduct that issued a consent order against him. And the record has been developed about kind of what that's based on. Dr. Murphy has several other licenses in other states, and as it's very typical in a bootstrap action, those started to kind of fall like dominoes. You know, once New York went, a bunch of the other ones went also. He has applied to practice in Ohio and has indicated that he wants kind of a very, he has a very narrow practice plan for Ohio, but the report and recommendation is granting his license with a probation. And you have not overstepped your legal bounds if you choose to do that. That is, I think, a very reasonable step for this board to take, given the fact that he has action from New York. So the state supports the report and recommendation with the proposed sanction of granting the license with a probation. Thank you.
Thank you so much. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Murphy? Motion, please.
So moved, Dr. Bechtel.
Thank you, sir.
Dr.
Second.
Johnson.
Thank you, Dr. Johnson. I will now entertain discussion concerning the matter of Dr. Murphy. Is there any discussion? I guess I had a couple thoughts. So I do think respectfully that the New York board could have been a little clearer in drafting the consent order. I say that because there are multiple factual allegations listed in the consent order, but there's only one actual violation, and that's the second specification, which references the documentation issue. All the other allegations that are listed were essentially dismissed. So this is a B-22 violation based on a minimal standard concern related to documentation, and the New York board permanently revoked the doctor's license in a voluntary consent agreement in which the doctor was represented by counsel. And so I appreciate the doctor's thought that the proposed order is onerous, but that is also a substantial discipline from another medical board. And so this is one of those B-22 cases where I really wish I did have more information. But that said, It's an almost 10-year-old violation based on poor documentation. There have not been any other violations of which we are aware, and the doctor's practice in Ohio is going to be very limited. So I think the order is fair. I appreciate the doctor's thought about the medical records course that he took the PACE program in 2015. I think it can be left to the discretion of the secretary and supervising member to weigh in as to whether to allow that course to be considered sufficient to satisfy the requirement. And then that matter could simply come before us again as a probationary request. So I support the order. Is there further discussion?
Dr. Schottenstein? Dr. Schottenstein?
Yes, sir, please.
Yeah.
Yes, sir.
I like you a little bit with this one too, in terms of it's 10 years ago. The only ding is the medical records. I'm just wondering, is 1 year probation a little much? I mean, can the probation perhaps run in tandem with the medical records course? For example, the respondent completes the medical records course and the probation ends. I don't see the value of dragging this out a year, quite honestly, if he takes the medical records course, given the limited practice scope. That might be maybe a compromise on this. So once he takes it, whether it's a month, a year, he's got to do it within a year, but that's when probation would cease. Again, I don't see a lot of value in prolonging this process, quite honestly.
Okay, thank you so much. I guess the other side of that is, if in fact then we have a sense that the board would be satisfied with the PACE course, right? And would allow that essentially to count for his documentation course. And if now we're contemplating the probation ending when he's finished his course, then the question is, should we simply revise the order to take no further action? Is there further discussion?
Well, just one follow-up to that. I guess my question is,
yes,
we feel comfortable that the PACE course coincides with Ohio's laws in terms of record keeping. If we do, I would agree. If we think there is some nuance in the Ohio record keeping requirements, then I'd say maybe we get him in a course that's specific for Ohio as opposed to the PACE course. But I don't know enough about the PACE course. If the PACE course covers it, I'm fine with that too. Sorry.
No, that's great. Thank you so much. Is there further discussion? Dr. Feibel.
Yeah, I am very uncomfortable with this case. If you think about our board and our board agreeing to a consent agreement where somebody has permanently revoked their license, represented by counsel, that would be something egregious. We would never make somebody permanently revoke their license unless there had been something egregious going on. We might have let them agree to a minimal standards violation to get the consent agreement. But I am very concerned about what the consent agreement really was from. And so therefore, I think the order that's currently in place is a minimum and would even entertain not granting him a license based on the fact that he permanently revoked voluntarily his license in another jurisdiction. It's very concerning. I realize it was 10 years ago, but again, to permanently revoke your license voluntarily, it had to have been something egregious. So I would not support any less than this for sure.
Yeah. Well, Dr. Schottenstein.
Thank you so much, Dr. Feibel. Yes, sir, please.
I think there's a difference between surrender and revocation, and it's New York, and having dealt with New York, it is a bit of a tangled jurisdiction to deal with in dealing with those regulators and the process. I'm not saying that doesn't mean that something didn't occur, but I just wonder, again, the only allegations other than the record keeping were 4 counts of negligence with patients, and I'm not even sure what those constituted, let alone whether he was, found to violate anything. So again, I'm looking at, the information we have before us, which is fairly limited. And a voluntary surrender, people get into voluntary surrender situations, sure, because they're trying to avoid prosecution. But a lot of times they just throw up their hands and say, you know what, this just isn't worth the effort to deal with it. And again, I don't know what this is because, again, we're limited in terms of what's in this information, which is fairly narrow. So again, I feel better if there was something, but do we assume worst case scenario when they didn't even force his admission of it? I don't know. I'm struggling with that a little bit. So I guess I'd probably stay where I was unless I saw something, unless somebody sees something here that maybe I'm missing that would dictate that it needs to be more severe. But I just don't see it on the face of the information we have. Thank you.
Thank you so much. I substantially agree with that. And again, just to remind us, those other allegations were dismissed. We're just dealing with the documentation issue right now for purposes of our discussion. Is there further discussion?
Yes.
Montgomery has discussion.
Just,
if you'd be so kind, please.
Just very, very briefly. I have to, with all due respect, not agree. I would want to, at the very least, leave what we have. We don't know exactly what happened in New York. We can't even begin to speculate at this point. We only have the practice, the medical records thing in front of us. He did have a lawyer. Whether that lawyer was well prepared or competent, we'll not know. That he would not understand that this cascading would happen by definition as a bootstrap across the country. But I would not want to, Mr. Giacalone, I would not want to have the probation less than what it is for that reason. We don't know what happened. It's a problem. I think everybody's articulated that, but I would support the report and recommendation.
Thank you, Ms. Montgomery. Is there further discussion?
Yes, I'd like to make a comment. Yes, thank you, Dr. Schottenstein. I appreciate all of the comments that were mentioned. I too support the proposed order as is. I support actually doing the medical records course, unless I'm missing something, at least from what I recall from reading the R&R. The medical record course that Dr. Murphy completed was in 2015. I think it's 2020 now, so a lot possibly has changed over 5 years. There's a lot to be gained and a lot of knowledge erosion that occurs over 5 years. So I don't think it's unreasonable to repeat the course. I do think carrying a heavier hand might be challenging given that it was a voluntary surrender type situation. If it was actually an ordered surrender or ordered revocation, I would actually agree with Dr. Feivel on that point. And those are my opinions. Thank you.
Thank you, Dr. Sohn. Is there further discussion?
Just one thing clarifying. I was not proposing an amendment that would be sterner. I'm just saying I definitely wouldn't go any less than what we have. So I just want to clarify that, Dr. Sohn.
Thank you so much, Dr. Feivel. Any other discussion? So let's vote then, please, with a roll call vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Murphy. Roll call, please. Dr. Rothermel.
Abstain.
Dr. Saffron.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn.
Yes.
Dr. Johnson.
Yes.
Mr. Ganadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feivel.
Yes.
Dr. Bechtel.
Yes.
Dr. John. Okay, yeah, so I guess that's me then, just yes for me as well. And so please turn then to the matter of Jada Ransom LMT. No objections have been filed. Ms. Szymanski was the hearing examiner. This matter is non-disciplinary and therefore all board members may vote. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Ms. Ransom?
So moved, Dr. Johnson.
Motion, please.
Second, Dr. Bechtel.
Thank you, Dr. Johnson. Dr. Bechtel, thank you. I will now entertain discussion concerning the matter of Ms. Ransom. Is there any discussion? I think it's a fair order. I think it's compassionate. I support it. Any further thoughts on this? Okay, so a roll call then, please. Vote to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Ms. Ransom. Mr. Rothermel?
Yes.
Dr. Safran.
Yes.
Dr. Rothermel, this is an R&R. Are you allowed to vote yes on this?
It's
Yes, I believe this is a non-disciplinary matter.
Right.
Yeah,
Undis-
therefore she can
Okay,
vote.
just checking. Thanks. Thank you so much. And Dr. Safran,
Yes.
Mr. Jackalone,
Yes.
Dr. Swan,
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you. In the following matters, the board issued notices of opportunity for hearing. No timely requests for hearing were received. These matters were reviewed by a hearing examiner who prepared proposed findings and proposed orders, and it's now before the board for position. These matters are disciplinary in nature, and therefore the secretary and supervising member cannot vote. In these matters, Dr. Rothermel served as secretary and Dr. Coughlin served as supervising member. Please turn to the matter of Harrison L. Coons Jr., RCP. Do I hear a motion to find that the allegations as set forth in the February 12, 2020 notice of opportunity for hearing in the matter of Mr. Coons have been proven to be true by the permanence of the evidence and to adopt the proposed findings and proposed order? Motion, please.
So moved.
Dr. Bechtel, thank you. Is there a second?
Second, Jackalone.
Thank you so much. I will now entertain discussion concerning the matter of Mr. Coons. Is there any discussion? Okay, hearing none. May I have a roll call vote, please, to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Coons? Mr. Coons, roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Swan,
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you. Please turn to the matter of Interpol Singh MD. Do I hear a motion to find that the allegations as set forth in the May 13th, 2020 notice of opportunity for hearing in the matter of Dr. Singh have been proven to be true by a preponderance of the evidence and to adopt Ms. Lee's proposed findings and proposed order? Motion, please.
So moved.
Dr. Bechtel, thank you. A second.
So moved, Dr. Jones.
Thank you so much. I will now entertain discussion concerning the matter of Dr. Singh. Is there any discussion? Okay, hearing none. May I have a roll call vote, please, to approve and confirm the proposed findings, conclusions, and orders presented in the matter of Dr. Singh? Roll call, please. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Soin,
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. In the following matters, the board issued notices of opportunity for hearing and documentation of service was received for each. There were no timely requests for hearing filed, and more than 30 days have elapsed since the mailing of the notices. These matters are therefore before the board for final disposition. These matters are non-disciplinary in nature, and therefore all board members may vote. On September 9th, 2020, the board issued a notice of opportunity for hearing to Rebecca Marlene Billings, DO, informing her that the State Medical Board of Ohio proposed to approve her application for license to practice osteopathic medicine and surgery, provided that she taken past the American Board of Internal Medicine certification examination due to the fact that Dr. Billings has not engaged in the active practice of osteopathic medicine and surgery for more than 2 years. Do I hear a motion to find that the facts set forth in the September 9th, 2020 notice of opportunity for hearing have been proven to be true by proponents of the evidence, and that the board enter an order effective immediately upon mailing, removing Dr. Billings' application, provided that she takes and passes the ABIM certification examination within 12 months of the date of mailing of the notice of opportunity for hearing? Motion, please.
So moved.
Dr. Safran, thank you. Is there a second? Dr. Bechtel, it looks like. Thank you so much. Oh, thank you very kindly. Is there any discussion regarding the motion? Okay, hearing none, roll call please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Sullivan,
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. On September 9th, 2020, the board issued a notice of opportunity for hearing to Mariana Oroz MT, informing her that the State Medical Board of Health proposed to approve her application for restoration of a license for massage therapy, provided that she'd taken past the massage and bodywork licensing examination at MBLS, due to the fact that Ms. Oroz has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the September 9th, 2020 notice of opportunity for hearing have been proven to be true by proponents of the evidence, and that the board enter an order effective immediately upon mailing, approving Ms. Oroz's application, provided that she takes and passes the MBLS within 12 months of the date of mailing of the notice of opportunity for hearing? Motion, please.
So moved.
Second.
Dr. Safran, thank you. Is there a second? Dr. Bechtel, thank you so much. Is there discussion? Discussion. Okay. Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Sullivan,
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel, sorry, Dr. Feibel, Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes.
I'm sorry, can I confirm
On
Dr.
September 9th,
Feibel's vote? I'm sorry, this is Benton. Can I confirm Dr.
Yes.
Feibel's vote? Thank you very much.
Yes.
Thank you for your indulgence.
On September 9th, 2020, the board authorized and issued a notice of opportunity for hearing to Rebecca Gail Shook, informing her that the State Medical Board of Ohio proposed to approve her application for license provided that she taken past the clinical simulation examination, or CSE, due to the fact that Ms. Shook has not engaged in the active practice of respiratory care for more than 2 years. Do I hear a motion to find that the facts set forth in the September 9th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing approving Ms. Shook's application, provided that she takes and passes the CSE within 12 months of the date of mailing of the notice of opportunity for hearing? Motion, please.
So moved.
Dr. Safran, thank you. Second?
Second.
Thank you, Dr. Bechtel. Is there discussion? Hearing none, roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Sullivan,
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery, Ms. Montgomery,
Yes.
and thank you, Dr. Feibel, Dr. Feibel, Dr. Bechtel,
Yes.
thank you, and myself, Michael Schottenstein, yes. I will now entertain a motion to go into executive session to confer with the medical board attorneys on matters of pending or imminent court action, and for the purpose of deliberating on proposed consent agreements in the exercise of the medical board's quasi-judicial capacity, and to consider the appointment, employment, dismissal, discipline, promotion, demotion, or compensation of a public employee or official. Is there a motion, please?
So moved.
Second.
Dr. Safran, thank you. A second? Dr.
Second.
Bechtel, thanks very kindly. Roll call, please. Thank you so much. sir. Roll call, please.
This is Benton. Can I ask a question before the vote? Considering the time, I don't know how long executive session will be. Dr. Schottenstein, do you want to have executive session and then perhaps a break for lunch? And this will help me inform the staff when they might need to come back.
Oh, so what's everybody's comfort level? Do you want to break? You want to keep going?
Keep going.
I'm fine to keep going. It's only,
Oh, yeah, very good. Keep on going.
okay.
Yep.
Thanks so much.
Sounds good. Okay, thank you very much. You can proceed with the vote.
You're very kind. Thank you so much. Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Soin,
Yes.
Dr. Johnson,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel, Dr. Weibel, Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. Thank you. So the time is 11:06 a.m. and the board's in executive session.
We're still
This conference is no
recording.
longer being recorded.
Okay, and are we going to a separate, go-to meeting or